This is a presentation of the Lex Rex Institute, where we're committed to ensuring that the law remains our only king and that everyone is subject to it, even our leaders. I'm Alexander Haberbush, and I'm president of the Lex Rex Institute and also a practicing constitutional attorney. As always, nothing in this video should be understood as construing legal advice. All right, so earlier today in our last video, we started to take a look at how courts treat precedent and discussed the idea of stare decisis. And I mentioned in that video that we were only going to look at half of the question and that we would save the other half of that question for later. Well, in this video, we're going to look at the second half of that question. So for those who have not yet seen the first video, I do recommend that. This one should make sense without it, but if you get a chance, go ahead and take a look at that one. In the first half, we discussed sort of what stare decisis is, how precedent works, and then gave a defense for it. Explained the reasons why our system is one that relies so heavily on precedent. And in this section, we're going to look at the rare exceptions when precedent will not be followed, or rather when precedent will be overruled, and examine when it ought to be overruled. And then we're going to look at another question that I think has sort of been lurking in the shadows up to this point. I have not stated it yet, but you may have caught on in our last video that there's a little bit of a tension that might be going on. And that's between, if you know anything about Lex Rex Institute, well, you know that we are a constitutional organization and we advocate the Constitution as it would originally have been understood. Not a lot of these subsequent case law modifications do. And we're often trying to push the court back to that original understanding of the Constitution. Well, how do you marry that idea of originalism, with the idea of stare decisis? Because if courts can make rulings that go against that, well, are we advocating following those rulings or advocating the Constitution? Maybe a bit of a tension there. I don't believe there's actually a tension there. I think it's actually a pretty easy question to reconcile, but we'll get to that in a little bit. You may disagree with my answer. That's fine. Go ahead, address it in the comments. We're happy to discuss with you. All right, let's take a look at the question we looked at last time. With everything in the news about the Roe v. Wade precedent potentially being potentially being overturned, I was wondering how precedent actually works. Do judges have to follow precedent? And if not, why does it matter if it changes? Again, great questions, huge questions. We're not going to be able to say everything about this today, but this is sort of a primer introducing you to the ideas. And in this video, again, we're going to look at when precedent ought to be overruled. So, just to mention it again, great deference is paid to precedent in our system. Although this deference is not inviolable. There must, however, be a strong presumption in favor of not overturning precedent, and we only do it in rare circumstances. Now, there are different sorts of circumstances in which precedent can be overruled, and those are going to be the different sorts of law that we talked about, again, in the last video. Remember, we had written versus oral law. And under that, we divided them into constitutional, statutory, and common law issues. So when a court overrules a common law issue, that's probably going to be your least common for a court to overrule, because those are ancient traditions, have been in law forever and ever. We don't really even know where they come from for sure. Statutory, those might be more common. Constitutional is going to be similar to statutory questions. But the key thing about constitutional questions, and the reason that this is such an issue that originalists need to deal with, is that when it comes to constitutional interpretation, there is no remedy for a bad ruling other than overruling that past ruling. That's not the case when it comes to statutory or common law issues, because think about it, on statutory issues, if Congress really doesn't like the way that the court ruled on a matter of statutory interpretation, they can just rewrite the statute, not a problem. Whereas on common law issues, there's a lot of different courts in this country, a lot of thousands, tens of thousands, hundreds of thousands of rulings on many common law issues. It'll get corrected at some point because there's a lot of other means of recourse you can go to. But on constitutional issues, the court's the buck stop for this stuff. I mean, we'll argue ultimately we the people are the backstop on this stuff. But the court, functionally speaking, within a structure of the three branches of government, they're going to be the backstop on matters of constitutional interpretation. So what do you do when the court gets it wrong? Well, certainly the Supreme Court has overruled its own precedent in the past. A few examples come to mind real quickly. West Coast Hotel v. Parrish overruled the Lochner decision, Lochner v. New York. Again, For those who don't know, Lochner was sort of the case that began the economic due process era of the court, where great deference was paid to the economic activity of various commercial actors, and this ends up being overruled I think in 1937 is when the West Coast Hotel case ends up being heard during the FDR administration. Some could argue there's a lot of political pressure on the court at that point, but needless to say, overruling past decisions tends to be fairly politicized. Not a great thing when that happens, but that does tend to be the way that it goes. Another one, very famous one, probably the most famous overruling of a past case, is going to be when Brown v. Board of Education overruled Plessy v. Ferguson. So Plessy v. Ferguson was the case that said separate but equal is still equal, and then Brown v. Board of Education comes back and says no, separate but equal is not equal. It's a violation of the Equal Protection Clause of the 14th Amendment. A few more that come to mind is going to be Bowers v. Hardwick, which overruled Lawrence v. Texas. That was an anti-sodomy case that sort of inducted the right to privacy evolving along the lines of protecting sexual conduct and then eventually culminating in the legalization of same-sex marriage. Again, very political. Also, another few more that come to mind would be Mapp v. Ohio, which is overruled by Wolf v. Colorado, and then Loving v. Virginia, which is overruled by Pace v. Alabama. But, and this is the important thing to keep in mind, out of the 25,544 opinions that the Supreme Court has issued on matters of constitutional interpretation, the court has reversed its constitutional precedents 145 times. 145 out of 25,544. That's less than 0.5%. So as we can see, it's very uncommon for the court to do this, especially in a way that just directly reverses a past decision and gets rid of that case entirely. Nobody can cite Plessy v. Ferguson anymore. It's not good law. That's a complete reversal of that position. That's very unusual for the court to completely reverse opinions like that. Some have argued, there may be truth to this, I haven't looked at the stats, but some have argued that overruling past opinions has gotten more common in recent decades. If that's true, that's a concerning trend, because as we mentioned in our past video, precedent is really what holds our legal system together. It's what keeps the judge from merely voicing their own personal opinion and interpreting the law instead. So, when does the court decide to overrule precedent, and when should the court decide to overrule precedent? Well, there have been a lot of different ways the court's talked about this over the years. The most recent is going to be in the case Ramos v. Louisiana, which is actually just decided earlier this February 22, for those of you who are February of 2022, for those of you who are watching this in the future. So let me go ahead and pull up what was decided in that case. So these are going to be factors the court traditionally looks at, and the court in Ramos cited these as sort of the traditional factors looked at for overruling a case. And those are right here. Those are going to be the quality of the reasoning is going to be the first one. Now that, you look at that, how do you analyze the quality of somebody's reasoning, right? That's something that's going to be highly subjective. I think there may be some objective criteria you can apply there, like whether or not it cites precedent, whether or not it cites precedent accurately, how faithful it is to the text of a statute. Those are all things that can affect the quality of reasoning. But at the end of the day, this is sort of a subjective consideration. And certainly the line between good reasoning and bad reasoning, wherever you draw that line, that's going to vary based on who you're talking to. So I would say probably not a great test, or at least the first factor in this test, probably not a great test because it doesn't have any clear delineation between what qualifies and what doesn't qualify. Next factor is going to be consistency and coherence with other decisions. So this one has to do with if there's a case that is just totally out of left field, has nothing to do with past precedent this court has had, and justices maybe just made something up totally inconsistent with the rest of the law. That's the sort of thing that's more likely to be overruled. Although in most circumstances, if it's totally out of left field and has nothing to do with the rest of our law, it's not going to be cited that often to begin with, and it might not even get in front of the court. Again, this can be fairly subjective, but I think this is a little bit more black letter, clear. I think it provides more of a bright line rule the judges can follow. Next factor that courts look at traditionally has been whether or not the law has changed since the prior decision. And what this is going to mean is that the case law has just evolved in a different direction than what this past decision said. Courts may have become clearer on the issue since it was last heard. That's going to be another factor. Workability is the next factor. Now, what does workability mean? This is sort of one that I've been alluding to even in analyzing these other factors. Workability has to do with whether or not the past case gives judges a clear rule for deciding future cases. So, what's a good example of something that doesn't do that? Well, you know, I hate to use the abortion example just because that's so contentious right now. I guess it's always contentious, but particularly right now. But late Justice Scalia liked to talk about this workability factor in criticizing the Casey v. Planned Parenthood decision. And what he would say is, so what was established in Casey v. Planned Parenthood is that the law may not impose an undue burden on a woman's right to obtain an abortion. And Scalia looked at this and he said, what on earth is undue? Different people are going to disagree on what constitutes an undue burden. Certainly I can't look at past precedent for what constitutes an undue burden, because if I do that, I'm going to look at 1,500, more than 1,500 years of common law history and see that punishing somebody with a homicide crime was not considered to be an undue burden on a woman's right to abortion. It was considered to be a due burden. That's exactly what punishment was due for having an abortion of a child. So the rule was not workable. Another really good example of a rule that is not workable was the obscenity standard the court had for a little while. So in deciding whether or not content was obscene such that it was not subject to First Amendment protections, for a little while the rule the court applied was, and I kid you not, this is a direct quotation from the case, I know it when I see it. Well, different people know things differently when they see them, so that was not really a workable standard. I'd argue the current standard actually might be a little bit worse, honestly. It has to do with, a lot of balancing tests of whether or not, according to the standards of the given community, taken as a whole, the work appeals to the prurient interest, and whether it depicts things in a patently offensive way. So other subjective considerations, so not much better, but a lot of the tests that we have are tests like this. And I would argue most balancing tests are not going to be terribly workable rules because, as we've mentioned before, most balancing tests just pit two interests against each other. Usually the constitutional interest, like free speech or free expression or right to bear arms, against some kind of government interest. So something the government just wants to accomplish. And government's always going to say they have a great interest in whatever they're trying to do to restrict somebody's free speech. And really, I think that it comes out to fairly subjective considerations whether or not a judge thinks that one thing outweighs the other. So I would say most balancing tests have trouble with this factor. This is an important factor. Next is going to be reliance interests. What that means is whether or not people have detrimentally relied upon the past ruling that a court has made. So how do you detrimentally rely on something? Well, say that the past decision had to do with developing in the wetlands, something having to do with that. And they said that it's fine to develop in certain wetlands areas. And a bunch of businesses did that. They built buildings there, they may have built houses there. Certainly there's a lot of commercial activity in an area that was previously a wetland. If a court were to reverse that decision later and issue a ruling that compelled people who had developed there to tear down that property and restore the wetlands, well, that would be hugely detrimental to people who had relied upon what the court had told them in the past. So economic interests are going to be significant here. Substantial personal rights are going to be significant here. Things that substantially affect somebody's life, like marriage or children or things of that nature, are going to be substantial reliance interests that would sort of push against overruling precedent. And the last one's going to be the age of the precedent. Cases that have been around for a long, long time are less likely to be overruled than cases that are relatively new. Although I'm not sure that's actually true. If the court rules something, it's not going to overrule that precedent 2 years from now. So, moderately long age is probably what you're looking at for best case scenario of overruling something, usually within a couple generations ago. That way it's same people aren't on the court anymore, but it's still a relatively new development. I don't want to comment too much on the abortion issue, but that's a 50-year-old case. That would probably fall in the window that makes sense to overrule precedent. I think generally when precedent gets overruled, it's about that long. If you look at the ones that I mentioned earlier, well, Plessy v. Ferguson was almost 100 years. But if you look at West Coast Hotel v. Parrish, which overruled Lochner, that's a little bit longer than that. So about that window is what we're looking at. But these are the factors that the court will usually look at when deciding to overrule a case. As you can see, there are a lot of problems with these, largely because they don't necessarily provide clear tests about which cases should be overruled and which cases should not. So in this Ramos decision that I noted earlier, Justice Kavanaugh actually wrote a concurrence opinion where he narrows these 5 factors down into 3 broad principles. And those principles are not just wrong, but grievously or egregiously wrong. You know, I'm not sure that that is all that much clearer, because while it does make it plain that it's got to be really wrong, not just, I guess, the ordinary garden variety kind of wrong. How do you decide whether or not something is grievously wrong? That doesn't seem like something that has a clear test that people will be able to anticipate ahead of time. Maybe I'm wrong. I don't know. Next is going to be significant negative consequences. He sort of collapsed, well, if you look at the other factors, he sort of collapsed reliance interests into that. I don't know that any of the others here really have directly to do with that, but that's one of the things that he identifies. I would take some issue with this because, again, if you watch our last video, judges are not supposed to be voicing their own opinions about things. They're not supposed to be inserting their personal views or preferences into what they rule. And assessing a negative consequence, to me, certainly seems like doing just that. Now, these could be negative consequences, practically speaking, but they could also be negative legal consequences. I think those would be more valid for a judge to look at. So what's a negative legal consequence? Well, that's something like overruling this case will overrule 200 other cases. And those 200 other cases have been acted upon by lower courts consistently across the board. And courts aren't going to know what to do if we get rid of this precedent because so many other things are based on it. That could be a negative consequence I think would be pretty valid for a court to consider. And then the last Kavanaugh principle is going to be undue upset to reliance interest. This is related to the negative consequences, but a bit distinct. We address that in the factors as well. And so reliance interests, as we mentioned, are going to be people who have detrimentally relied upon this case. Kavanaugh adds undue here. He just makes it a little bit higher of a threshold that it has to surpass. So I've addressed this question, this week's question, this entire video, sort of in reverse from how we usually do it. Often we will look at the history, what it was supposed to look like originally, what the concepts are at play, and then how those concepts have been dealt with by the court and interpreted in the way that they apply today. Today I've looked at the most contemporary case that has analyzed this idea of overturning past opinions. Now I'm going to look at the principles that that case was supposedly based on, as well as the principles that I think ought to, and in fact do, apply to when precedent should be overturned. So let's take a look. We're going to look again at our friend William Blackstone. We show a lot of him here. Forgive me for that. Like I've mentioned before, he was sort of the founder's Bible on this stuff, so makes sense to look at him. But let me go ahead and pull up this quotation from William Blackstone. So, the very broad statement that he gives regarding precedent is that the doctrine of the law then is this: precedents and rules must be followed unless flatly absurd or unjust. And I want you to keep that in mind when we look at the rest of these standards we're going to talk about. So I'm going to pull up something from my text of Blackstone's commentaries. Let me go ahead and do that. All right, so taking a look here, this comes right after the section we looked at last time, talking about how judges are not to insert their own opinions, but merely to maintain and expound old laws. And then he follows that up by saying the exception to that rule. He says, yet this rule admits of exception. Where the former determination is most evidently contrary to reason, much more if it be clearly contrary to the divine law. But even in such cases, the subsequent judges do not pretend to make a new law, but to vindicate the old one from misrepresentation. For if it be found that the former decision is manifestly absurd or unjust, it is declared not that such sentence was bad law, but that it was not law. That is, that it was not the established custom of the realm, as has been erroneously determined. Okay, so a few concepts that are going on here. I'm going to try to break it down for us. So, first concept that we have is that laws may be overturned when they are contrary to reason or contrary to the divine law. Now, these are going to apply slightly differently in a constitutional context, but I'm going to get into that in a minute. First, what I want to draw your attention to here is the second of the two reasons, when it is contrary to divine law. Well, what does that mean? Now, as we've mentioned before, when it comes to jurisdiction, lower magistrates, lower sovereigns are always going to be subject to higher sovereigns. In the Christian worldview, and William Blackstone was a Christian, as were many of the founding fathers and many of the judges throughout English history. I'm not saying that you have to be a Christian to be a good judge or to understand the law. Not at all, I'm not saying that. But that's just a fact about the history of the common law tradition, is that that was the way in which they conceived of things. And they viewed God as sort of the ultimate sovereign. He's the one in charge. You go all the way up the chain of command, you get to God. So when Blackstone says that a law is overruled when it's contrary to the divine law, what he is meaning to say there is that a law will be overruled when it is contrary to a higher one, which is directly relevant for our purposes as a constitutional republic, because we don't have to go all the way up the chain of command. We can just go one rung higher from where we are right now by looking at the Constitution of the United States. That's always going to be more authoritative than precedent. And actually, Alexander Hamilton says exactly that in Federalist 78. Let me go ahead and pull that up for you. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and validity ought, of course, to be preferred. In other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents. So he's applying this to statutes here. Of course, the same thing would apply when talking about precedent as well. Constitution's always going to be more authoritative. So if there is an explicit contradiction in the Constitution, you would always have to go with that above and beyond whatever is in precedent. So that's exactly the test that I'm going to give you for when precedent can be overruled or ought to properly be overruled. Let me just state that for you right now. Precedent should be, in fact, must be disregarded when it is impossible to reconcile it with the Constitution. Now, let me stress several words in that. Must be disregarded when it is impossible to reconcile it with the Constitution. Now, I didn't say when it's very difficult to reconcile it with the Constitution. I didn't say when it's very unnatural to reconcile it with the Constitution. I believe that judges, if an opinion can be reconciled with the Constitution, they owe it to do that, because they do not have authority, really, to be voicing their own views about what is and ought to be the case. They owe it to past judges to continue to respect those decisions going forward. This would take into account that workability factor that we were talking about earlier. And I would argue that any law which is fundamentally unworkable, that is, any law that doesn't provide a clear test for when something's permitted and when something's not permitted, is one that is inherently irreconcilable with the Constitution, because laws that do not provide clear rules are fundamentally incompatible with the character of a written Constitution. Think about it. Great Britain, obviously prior to the foundation of the United States, had an unwritten Constitution. We introduced a written Constitution. That's an innovation that we made. Why would we do that? Well, the only conceivable reason to put a Constitution in writing is because you want it to be clearer than the Constitution that is unwritten. You want people to be able to point to it and say, no, this is the law. Whatever other thing you're saying, that's not the law. So if we have a doctrine for interpreting the Constitution which requires us to treat law with ambiguity or treat constitutional issues with ambiguity, that is fundamentally incompatible with the character of the Constitution. So I think that factor, totally valid. In fact, I wouldn't even make it a factor. I think that it can be a bright line test. If a particular ruling does not produce a workable standard, it cannot be constitutional. Now, let me turn back to the other portion of what William Blackstone had to say. Let me pull that up one more time. All right. But even in such cases, the subsequent judges do not pretend to make a new law, but to vindicate the old one from misrepresentation. What does that mean? Well, as I just mentioned, when you overrule past precedent, you are not merely saying that a particular case is wrong and that you're replacing it with a new thing that you made up or a better standard that you've come up with now. You're saying that that case was never right to have been decided that way. Judges never should have ruled that way on that old case. They should have ruled a different way. They should have respected the higher law, the more ancient law, the more tested and true, and frankly, the law that has more precedent behind it. So even when you overrule past precedent, well, you're still actually respecting precedent, and you are at least making the argument that you've respected it more than if you hadn't overruled that past decision. Let me go on here. For it to be found that the former decision is manifestly absurd or unjust, it is declared not that such a sentence was bad law, but that it was not law. So again, if a past ruling is overruled, that decision is considered to not have been law at all. It was just wrong. It was wrongly declared to be law at that time. We got it wrong. We're getting it right now. And Blackstone actually goes on from this. I won't find it because I'll be scrolling around for too long. But he goes on from this to say that decisions of courts of justice actually aren't law. What? I've been talking about them like they're law this whole time. Am I going crazy all of a sudden? Well, maybe, but I don't think so. So when I say that they are not law, and what Blackstone says when he says they are not laws, he says that they are evidence of what is common law. So here's the full quotation. Decisions of courts of justice are the evidence of what is common law. That's the entire reason why a past decision can be overturned, because the decisions themselves were never the law. The content of the law was always something that either existed in the written statute or in the written constitution, or something that existed in a higher natural law, a law of the creator that endowed us with our unalienable rights, as Thomas Jefferson put it. When the court expressed its opinion, all it did was tried its best to express its reasoning for why the conclusion that it was making was consistent with the law. And because judges are duly empowered people within our government who we've put in charge of making that decision, it's really, really good evidence of what's law when you look at those judicial opinions. It might be the best evidence that you have. It might be like bringing, 20 witnesses to court when your opponent only has one. You got way better evidence than they do. But there's always a possibility that your 20 people were wrong or mistaken, while the one person that your opponent has was correct. So while judicial opinion is very, very good evidence of what the law is, it's not the only evidence of what the law is, and it's not infallible. So keep that in mind. Courts may overrule precedent, and it's appropriate to do so. Again, to state that rule that we gave earlier, it's appropriate to do so when it's impossible to reconcile that precedent with the Constitution. So earlier when we looked at this, I talked about one part of when Blackstone said that laws could be overturned, and I did not address the other. So I'll talk about this divine law portion right here, but he also mentions when they are contrary to reason. Now, understand when he uses the word reason, he's using it in a very specific context. Those who are familiar with 18th century thought will be aware of this. Even in 18th century thought, different thinkers use the word very differently, but basically what he's hinting at is some kind of a natural law, the light of reason which the Creator has given to man, which enables him to see what is good. However imperfectly he's able to do that. And Blackstone goes on about that at great length in the first book of his commentaries, where he talks about how we do not know the divine law perfectly through reason, and that's sort of why judges are here and why we have, in his view, the Holy Scriptures to help enlighten us about that. Very, very important that he doesn't mean reason the way that we would think of it, sort of the post-French Revolutionary way of talking about reason, which is going to be reason as There's going to be reason sort of as an abstract absolute, reason as that which is reasonable to do. And if that's what he meant, this would virtually require judges to insert their own personal opinion, and that would directly contradict the rest of what he says. So reading this harmoniously with the rest of his work, I think it's very clear that he can't mean that. So what does that do then to this quotation from William Blackstone? Remember, this is the one that I had you guys look at earlier and asked you to keep in mind throughout the rest of the video. It is from William Blackstone. Not sure why the attribution's not here, but remember, this is the summary of when it's appropriate not to follow precedent. And here he says they must be followed unless flatly absurd or unjust. Well, while that may have been ambiguous before, what constitutes absurd, what constitutes unjust, ought to be very clear now. A law is absurd or unjust when it meets those other threshold criteria that William Blackstone talked about. And I summarized that in an American constitutional context as it's flatly absurd or unjust when it is impossible to reconcile its meaning with the text of the Constitution. That is when that precedent should not be followed, in fact, must not be followed. And again, just keep in mind, last point I want to leave you with before we end this video, even when the court overrules precedent, we call it overruling that precedent, but really, it's just following other precedent. It's following the better precedent, the more authoritative precedent, the thing that it's argued has more precedent behind it. So courts are always going to be ruling on the basis of precedent. They are always going to be following precedent. It's just a matter of which precedent at some point. And that's a difficult question to answer. Hopefully I've given you guys a clearer idea of when that's appropriate. Now, when you read a case that overrules past law, or you look at something that's challenged might overrule past law, hopefully you'll be able to analyze that. You shouldn't just be inserting your political opinions of, I don't like XYZ and this Supreme Court case protects XYZ, so I think that it ought to be overruled. That's a really bad way to look at law. If you do that, shame on you. It's not the way you ought to be looking at law. It shouldn't just be your own personal opinions of what's morally right and wrong, because if we do that, then every man does what's right in his own eyes. Because there is no Constitution. Because there is no king, and the law is our king. So anyway, that should be the last thought that I'll leave you guys with today. Hopefully you enjoyed the video. If you did enjoy it, make sure to hit like, hit subscribe, click on the bell icon, all of that. If you feel so moved, please contribute. Any amount really does help. That's all for today. This has been a presentation of the Lex Rex Institute. Have a great weekend, everybody.